Welcome back. Time to get a little bit more serious. Now, not many of us think about dying often, and when we do, it's too much of a somber thought that we choose to think of happier things. But in the week, David Knott of Private Client Holdings made a case for practicing your death to ensure that your executor and family know where to find your most important documents. What exactly should you prepare for in the case of your demise? Let's discuss this. We've got Anne Klein, Fiduciary Specialist at Maitland, and then Brink, MD of Crest Trust Services, joining us to take a look at all the steps you need to take in planning for that eventuality. Thanks for joining us today. Ian, I'll start off with you. Let's talk about the first step. What do you first need to do in the planning for, when you move on?
I think one should start off by planning to die. That is probably the one to start off with. Important is to make it easier for the executor and the family that are left behind to administer this estate. Obviously, there are various roles that need to be fulfilled, questions that are asked by the family and documentation that has to be lodged with the master's offices and so forth before the formalised administration of this estate can be done. And I think so it's very important to get the documentation in order beforehand, and then obviously get as much information as possible to the executor so that he can proceed with his executorship. I
mean, it's interesting. I actually tried it this week just to see what would happen if I stopped. I started going through my bank, who would pay for my kids, what would happen to it if, and I realized that life would actually literally come to a screaming halt for myself, but also for a lot of people who are dependent on me. What are the common mistakes people make when they think about it? Because a simple thing like paying for my child's school fees in the month, and suddenly it disappeared.
I think probably the biggest concern, especially from our side, where the administration of the deceased estate, is that there's a cash shortage. And I would go as far as to say that probably as much as 60% of the estates that we administer has a cash shortage. In other words, during the process of the administration of estates, there is not enough cash to cover the costs, such as looking after the family and so forth, covering the costs of the liabilities within the estate and so. So
until such a point as the assets can be distributed.
Absolutely, because probably leading on to that, I would say that the interim period from date of death until the appointment of the executor, which can take a couple of months if there's hold-ups and so on. During that time, nobody can do anything. No cash can be collected for the estate. No cash can be used towards the family and the dependents and so forth. So one, I think, would, and I think have to look from that side, is to see how do we cover that? How do we make it possible for the families and the dependents to be cared for during that process?
Mm-hmm. And let's get you into this discussion right now. I mean, when we're talking about the documents that are needed, there's a variety of documents you need to think about. So take us through some of the more important ones.
Well, I think what's quite important is to make sure that you know where your original will is. That's very important. If you don't have a will, you need to consider drafting a will and get expert advice on that.
You can even download them. I know you can go online and look at a template and download a template.
Yes, you can do that, but it all depends on your family structure and your asset structure. So I would believe that it's still better to get expert advice. There's a lot of people within the industry that you can approach to get the advice. So you basically need copies of, you would need the identity document of the person, you would need the death certificate. So you can really only start working on the estate once you get the death certificate, and that's quite important. You also need documents relating to assets and liabilities. If you're married out of community of property, you would need the antenuptial contract. If you are divorced, you would need those documents, and details about all your beneficiaries and the information. So that's just important.
Is there a way that you should bring your family or your partner into this whole process and involve them and prepare them for it? Should you be discussing it with them?
Yeah, absolutely. The whole situation is a planning situation, and I think one should involve the whole family as far as possible, because you often will leave the family with surprises and not expecting what the consequences are of a will that was drafted without there. And I'm not saying that their knowledge must be, they must be knowledgeable as to exactly what the contents of the will is, but probably look at what the consequences are of inheriting. In the sense that, and I'm probably referring to situations where property is left, and farming property specifically, is left to a child because the tradition is that it will be passed on to the eldest son. And the eldest son is a professional, qualified person. He has no intention of farming, whilst the youngest son is probably the guy that wanted to farm, but so that could leave them in a sort of a predicament, and the eldest son now inherits the farm, and he's not, that wasn't his idea to go farming.
This is morbid fascination, but I literally went through this because I was intrigued by it. So I assumed yesterday I would die. And now I'm going to get, in theory, I'm going to be paid in 10 days' time, but I've got a whole lot of debit orders that are going off, and let's assume that they're obviously going to go off because there's no money in the bank account. How do I communicate? How does somebody communicate to all of these people, all of my stakeholders or creditors, that it's not something that can just be left for a couple of weeks and hope that it goes away, because it immediately impacts, whether I'm alive or dead, it impacts the credit record, but just the general maintenance of it. What's the process from the moment that something happens?
Okay, what will happen in practice is after someone's funeral, you will consult with the executor. The executor will gather all the information and start informing all the relevant parties of the death. Once you've got all the documentation, you will lodge it with the Master of the High Court and get your letters of executorship issued. After that, there's a whole process to follow, so it will take a bit of time to pay creditors and so forth. But once you have informed all the parties, at least you've placed it on record.
Now, the executor is an essential and very critical appointment, really, essentially. You have to think long and hard about who's going to take on that role further down the line. They obviously have to be aware of the responsibilities that come with it. So take us through your views on the appointment of that and what we need to know about the roles of that executor, especially if you're appointed one of someone else's.
The most important thing, I think, is to realize that the executor is the person that actually stands in the shoes of the deceased. He takes over the responsibilities, and the whole process from there on, as if the deceased had been there himself. Probably what one should realize also is that understand what the executor needs to do, and do you trust him to do what you would have done had you been alive. So he takes over the responsibilities, he takes care or takes charge of the assets and liabilities, and he actually collects the assets. In short, will collect the assets, pay off the debts, and whatever is left will be transferred to the heirs in terms of the will. But the situation may be that where the executor is administering the estate, the situations like businesses that need to be run are, and don't understand me incorrectly, and saying this is it's a situation where the estate is actually frozen. Nothing can happen. You mentioned, what about the debit orders and so forth going through or not? That is what we refer to as an estate being frozen. Nothing can happen until the executor is appointed and takes charge of these assets and liabilities, and actually then continues winding up the estate and then finalizing it by transferring the assets or whatever is left to the heirs.
Mm-hmm. And what are some of the things that go wrong? I mean, are there instances of fraud or theft in the process? What do we need to be aware of?
I think to come back to your question in terms of who should be appointed, it's quite important to choose the right executor. Look at a good company. If you do have an attorney who you can trust, maybe look at appointing an attorney. In practice, I'm sure it does happen, but we are closely regulated by our professional bodies, and some of us are also chartered accountants, attorneys, and so forth. So there's a fiduciary duty on us to ensure.
But should your executor be a professional or somebody who's linked it? Because I mean, often I look at it, and I know in a couple of family instances it becomes somebody, it'll be your brother or your father or something, but you know, they're emotionally involved in the process as well. You know, what's the advice there in terms of the role?
Once again, it all depends on the circumstances. It's good to maybe look at a family member, but the family member would need to approach a professional to assist them with the administration process. So ultimately, although the executor will be responsible, he needs to appoint an agent to assist them. But if it all, you know, you need to look at, isn't it better to appoint a professional from the start?
What are the costs then involved? I mean, how essentially are executors, if you're a professional, remunerated?
The remuneration of an executor is determined in terms of the Deceased Estates Act. And it is normally set at 3.5% plus the VAT, which would relate to 3.99%. But it is only calculated on the assets that the executor actually handles. In other words, assets that are paid outside of the estate to beneficiaries, such as policies that were ceded or where beneficiaries have been appointed, will not be taken into the calculation. So from that point of view, it's set as a maximum. But obviously, the client has the opportunity to negotiate with the executor for a reduced fee.
I've gotten the sense, having seen a couple of people have been involved in the process, it's an incredibly long process. It doesn't seem to wrap up very quickly, even with professionals running the process. Where is the bottleneck? Why do we battle to get these processes wrapped up? I mean, you know, it's a silly example, but I still keep getting an SABC TV license for my grandmother, and I keep getting chased by them for something that's now 10 years old. I mean, how do where is the bottleneck in the process?
I think, once again, I think the bottleneck in this instance would be a rather long bottleneck, because it starts off from the reporting of the estate, which, as Anne said, you know, if the documentation is correct once the estate is reported to the Master's Office, it does make it easier from there on. But you are sort of subjected to the transfer of properties, where that needs to be done via the Deeds Office. You've got the last tax returns of the deceased needs to be lodged with SARS, you know. So you have a lot of other organisations and parastatals that are involved in this. And we don't want to say that we transfer this blame to somebody else, but those are the sort of situations, I think, that lead to a possible sort of idea that the estate takes it takes long to be wound up. But that is something that can be overcome if your documentation is correct right from the beginning. You have the correct documentation available.